Um, Good morning, everyone. I'd like to thank you all for being here and for the continued turnout and willingness to engage with Professor Gopal's lectures. I won't hold him back because he's very excited to begin today. So thank you, Professor Gopal.
Thank you. Thank you. Thank you, everyone. I'd like to wish everyone a very good morning. And thank you very much for your presence and engagement yesterday. We had a number of questions, and then we followed up with and stayed here till those who wanted questions were answered, and we discussed it. So for me, all this is about learning for myself, and all these discussions are extremely helpful. And so thank you very much. So I'll spend today the first few minutes, 5 to 10 minutes, sort of carrying over from yesterday for those who were not here yesterday, and for all of us to sort of just sum up what we did yesterday, because we discussed a lot yesterday and many of these were new ideas, and some of them were very simple ideas. And frankly, it's more difficult to communicate and understand simple ideas than complex ideas, because we are somehow geared to search for complexity, even when there is simplicity. So we'll sum that up, and then I will discuss in this first session the very contentious issues of religion and caste and reservation, because what I'm planning to do in each area is to identify a set of doctrines that have been developed by our courts, which are weakening democracy. So I identified 2 doctrines yesterday, and I'll identify a few doctrines around these 3 areas which are weakening democracy. Then in the next session in the evening, we will look at equality and liberty and identify doctrines relating to equality and liberty that are weakening democracy. And then I'll mention the other 6 or 7, 3 or 5 or 6 other areas where also there are doctrines, but we won't have time this time to go into any depth, but I'll mention them, and we can always have a discussion on them as well afterwards. We would like to have a half an hour interaction before I end in both sessions. And then in the evening, I'm happy to stay here as long as you want. I'm only leaving tomorrow morning to answer any questions or have any discussion, which we can do here, even if there are only 5 or 10 people. I'd be very privileged to continue that discussion. So with that, let me just sum up my main purpose. I have 2 main purposes. One main purpose is pedagogical, to try to think different and think of what we are familiar with in new ways. And that's a little bit at the heart of the struggle we are going through in India. One side is saying, think in old ways, don't question. Another side is saying, no, we want to think in new ways. Right? So I'm certainly on the second side, and I want to think in new ways. And maybe what I'm thinking is not right, but if it will provoke you to think in even better ways, in newer ways, then my job would be done. That's my first, my first and most important pedagogical purpose. Now, to implement this, the second purpose is basically to illustrate that through a different analytical framework with which to understand the Constitution as a site of struggle and not simply a set of rules, and also to understand, to analytically question who is responsible for our losing our democracy and what is our responsibility as members of the legal profession. Now, one person mentioned to me yesterday that I cited 2 sources, 2 sources to show that we've lost our democracy. There are many other sources that are saying the same thing, but for lack of time, I used the most credible and the most detailed source, the VDEM, Varieties of Democracy, from an independent source, a public university in Sweden, very large set of researchers who are working on this and have data covering 200 years. Also because till 2008, which is towards the end of UPA 1, India was a liberal democracy. And according to them, the slide to autocracy began at the end of UPA 1. They are critiquing the current government, because it is a current government, whichever current government it is. But they are saying actually that the slide to autocracy began towards the end of UPA 1, and UPA 2 pushed it forward, and that has continued. So this is not about flags. This is not about politics. It is about looking at, at what is happening to our democracy in a kind of transcendental manner. And the criteria are also very specific that they identify. Do we have freedom? Do we have liberty? Are we free to speak? Even unpleasant things, especially unpleasant things. If I have to speak in a way that will upset nobody, I have no freedom. I have no freedom. And so if upsetting people becomes a restraint on my speech, then frankly, there's no democracy at all. So we know that we have lost our democracy. We just need to wake up to it. We don't need any data. We don't need any analysts to tell us. We live in this country. We know we have lost our democracy, not because of one party or another, because of deeper trends. And I am arguing that democracy has been weakened. It did not start in 2008. It started much before that, from within days of our constitution coming into effect. The judiciary started to issue, like it happened in the United States, the judiciary started to come up with doctrines that will actually counter democracy. And I also want to mention that the American Civil War, 1861 to 65, took place in the 8th decade of their constitution. We are in the 8th decade of our constitution. And so in these first 8 decades of the Constitution, the judiciary in the United States was firmly against democracy. And so but I think when all of you sit on the Supreme Court and argue before the Supreme Court, we will go to the next stage where the legal profession will start to realize that there is a new conception of democracy. And you will fight for it. And we will move beyond these first 8 decades where, the Civil War was provoked, amongst other factors, by the infamous, disgraceful decision in Scott versus Sanford, right, 1857, where the Supreme Court held that a human being, a Black African American, was only a piece of property and not entitled to be a citizen. And we saw that several years after that, the US Supreme Court refused citizenship to a North Indian Punjabi who claimed to be an Aryan Aryan Hindu and therefore a white person, saying, no, you're not a white person, you're not fit for citizenship in this country, and upheld a law that forbade citizenship to naturalization of citizenship to those who came from Asia. So these are the disgraceful decisions of the judiciary, which were issued by some of the best judges. Chief Justice Taney, who issued the Scott versus Sanford decision, was widely considered to be a wonderful judge, a great jurist, but he was socially blind. He didn't understand history. He didn't understand the movement of time, of society, and he was narrowly focused simply on his limited understanding of society and his limited understanding of his craft. So to understand this a new way, I'm presenting to you an analytical framework which begins. Where's the gentleman here? It's showing here, but it's come there. It's come there. See, let's say we are dealing with cases where there is a conflict over normative constitutional provisions, not administrative, but normative constitutional provisions. Parties and judges, and after I've had this little experience in arguing before the Supreme Court, I realized that the lawyers and the parties are equally complicit in this. It's not just the judges. The parties and judges offer or take interpretations. The word interpretation, as I said yesterday, means defining the meaning of something is interpreted. So they offer interpretations of normative interpretations of the Constitution. The parties select. The judges may agree or may not agree. They will also select, but both the parties and the judges select a normative doctrine that is laid down in a precedent, or if that's not possible, they create a doctrine like the illustrious lawyer, Mr. Nambiar, did in taking the work of a German scholar and formulating the idea of a basic structure. They create a doctrine derived from existing judicial doctrine and existing principles of law. And in this way, the Constitution grows. It is shaped by the lawyers and the court. But they are selecting a norm. Even through this process, they're selecting a norm. The lawyers and the parties and the judges. What is the norm what is the ultimate source of the norm they are selecting? Even if the immediate source is a judicial precedent, ultimately you keep on going one judicial precedent after the other. You reach a point where a judicial precedent actually draws on a social source. That's the ultimate source of the norm that is selected, filtered through judicial decisions. What is that ultimate source? That is a moral or ethical norm. It comes from morality or ethics. And they are actually the same meaning. Ethos was translated into Latin as more. So they mean the same thing. It means a set of norms, basically a set of principles and practices about what is right and wrong. So they pick a norm, a value from society. And now the question is, where do you draw it from? Is it from, sorry, it is IPSE, not IPSI. It's a spelling mistake. I'm not going to disturb the presentation by correcting it. Ipsi dixit. Ipsi dixit. Ipsi dixit simply means what I say. If something is right because I say it is right. Ipsi dixit, I said so. Why do you say that it is wrong for dogs to want to listen to our discussion like happened yesterday? Ipsi dixit, because I think it's wrong. No other reason. Or you draw it from axiology, from social philosophy. Either your own sense of what is right or wrong, or you go beyond the law to look at accepted or whatever philosophical doctrine. In other words, some thinker has thought about these normative issues, has articulated a position. It may be Socrates, it may be Plato, it may be Kant, it may be anyone, but someone has thought about it, or it may be a religious text. Someone has thought about normative issues, and after careful thinking, hello ma'am, I didn't see you see you earlier, nice to see you. Honored to have you here. So they will select something from some product of some body of thought, which we call philosophy, and axiology is a part of philosophy that deals with values. How do you create value? So somebody has argued that there is value in something, and we draw from that and then say, okay, because we have to have, otherwise it becomes ipsi dixit. So we draw from that. So what I am trying to argue here is that our judiciary is drawing a lot from axiology. We want to identify the axiology from which they are drawing their norms. Because what we are now finding, you may not see this last sort of curve there, what I call theocratic judging is when the parties and judges go straight to axiology, bypassing all those processes. And we see that in many judgments now, straight going to the Veda. So one Supreme Court judgment said, dharma is constitutional law. Now, that's bypassing this whole thing and going straight to axiology. Right? Otherwise, there's a process. You go through judicial precedent, you understand, you go through that, and then you have a certain discipline to identify even the axiology. But this is ipsi dixit, going to the axiology that you think is right, without explaining why you're picking that axiology. And that methodology is also, this methodology, so we have the wrong axiology being picked. Wrong, why? Because they're picking on from the perspective of, if you want to defend democracy. Now, democracy is debatable, whether it's a right system or not. I believe in it. A lot of people don't believe in it. But if you believe that democracy is the right system, then we are picking on an axiology that has been frozen in time since the days of Plato, that are simply focused on order, virtue that will uphold order. That's that was Plato's idea of justice. And the ultimate idea of justice overall of the Indian judiciary, according to me, is virtue that will promote order in society. And so we have not moved beyond the 4th century BC, whereas after that, ideas of justice have evolved in different parts of the world and in our own country in many different ways. But we have not taken account of that in our own jurisprudence and our own method of thinking. So this is the analytical framework that I'm using. We can differ on what is the axiology, how to characterize it, but this is the methodology that I'm using. And ultimately, we are concerned about the impact of this on democracy. And I'm saying that this weakens democracy. So this is the basic argument I've suggested yesterday. And I also offered two, as an illustration of this, I offered two doctrines that have weakened democracy, the A.K. Gopalan doctrine, and I've slightly edited it, keeping the words, that the power of detention must naturally be left to the government, because the government is responsible for security and order whenever they think the occasion demands it, whenever they think the occasion demands it, in the interest of the security of the state and the maintenance of public order, and there is an etc. there. So there's a deference which actually is carried over from what I call the Raja era and the Raj era into the Swaraj era. It doesn't belong in the Swaraj era, but it's been carried over from the Raja era and the Raj era into the Swaraj era, which are the three phases I sort of classify our Indian legal development into: the Raja era, the Raj era, and the Swaraj era. So they are just actually within 3 months, 23 days after the constitution came into effect, they are reaffirming the Raja era and Raj era doctrine that we defer to the government. And that's why lots of people are today in jail. All the government needs to say is, we are concerned that there is a threat to national security and disorder. That's enough. Then you'll go to jail for many months and you may get bail after that when there's no evidence to prove it. But a mere bald claim is enough for that. And the second doctrine, the Chempakam doctrine I suggested to you, is that is that fundamental right to equality protects the caste oligarchy, not just the marginalized, but the oligarchy. And this was said, again, 14 months and 14 days after the constitution came into effect, because that is restoring not the Raj era, the Raja era. Because the Raj era did not necessarily, largely did, but did not necessarily guarantee protection of the oligarchy, of the Indian oligarchy, but they did protect, the Raja era was absolutely controlled by the Indian oligarchy, and so we are going back to it. Now, just to continue from yesterday a little bit, I just want to invite you to see this and then move on to sorry, just yeah, this is the one. See, this is the judgment that could have been written in Chempakam Rajan. So my argument is that the doctrine of reverse discrimination, which was introduced, which was the description given to the decision of the United States in the Bakke case, Regents of University of California versus Bakke, is the doctrine that 27 years ahead of Bakke was enunciated or promulgated by Chempakam Rajan. There, it was a complicated decision. Very narrow majority upheld the reverse discrimination and struck down. See, basically what the University of California did was, like we do, they created two categories of minority applicants and non-minority applicants, and they had separate lists like we do for reservation, and they took into, they had different, different criteria for these two groups, taking into account the discrimination against them. And the end, it merged because those who finally decided on admission looked at the list that came out of both streams and decided whether they meet, necessary criteria to be able to be successful students. But the selection criteria was different. And so this was challenged by Baque, who applied, for on two successive occasions for admission into the medical college of the University of California Medical School, and was rejected. And the courts basically gave him admission and quashed the system of admission into medical school. But Justice Thurgood Marshall, one of the greatest voices for marginalized sections, I would say, in the world, the first African-American judge in the US Supreme Court, a renowned lawyer for civil rights, very powerful intellectual, towering figure. He was on the court. He wrote a dissent. And that dissent addresses the same issues that came up in Chempakam Dore Raja. So Justice Marshall says, I do not agree that petitioner's admissions program violates the Constitution. For it must be remembered that during most of the past 200 years, the Constitution as interpreted by this court, we are in that same phase, first 8 decades of the Constitution. The Constitution as interpreted by this court did not prohibit the most ingenious and pervasive forms of discrimination against the Negro. So they did not use the provisions of the Constitution to prohibit the discrimination that the Negro was facing. Now, when a state acts to remedy the effects of that legacy of discrimination, I cannot believe that this same Constitution stands as a barrier. 350 years ago, the Negro was dragged to this country in chains to be sold into slavery, uprooted from his homeland and thrust into bondage for forced labor. The slave was deprived of all legal rights. It was unlawful to teach him to read. Just like for the Avarnas here. He could be sold away from his family and friends. There's slavery here, lots of books. There was widespread slavery in our country. It was unlawful, and at the whim of his master, killing or maiming him was not a crime. The system of slavery brutalized and dehumanized both master and slave. I'm just inviting you to read this. I'm not going to read the whole thing. By narrow and ingenious interpretation, the Supreme Court's decisions over a period of years, that's what I'm arguing here, had whittled away a great part of the authority given the government for protection of civil rights. He didn't say the government protected, but the authority given that he sees in the Constitution for protection of civil rights was whittled away by the Supreme Court. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage, he's now quoting Harlan, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws. This is the question, when will reservation stop? Is what another court asked. When will reservation stop? At some point it has to end. This cannot go on. Harlan dissented, this was the majority view. As Mr. Justice Harlan noted in dissent, however, the Civil War Amendments and Civil Rights Acts did not make the Negroes the special favorite of the laws, but instead sought to accomplish in reference to that race what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as freemen and citizens, nothing more. I just lost a case arguing the Kerala High Court against a rule that only Malayalam Brahmins can apply to be priests of Shabarimala temple, on behalf of two non-Brahmin priests with 20 years of experience. I argued on the basis of 14, 15, and 16, and the High Court said, that because there were not enough pleadings, they will not consider those arguments. Right? They claimed a tradition without any proof of that tradition. Not one iota of proof was ordered. So this is what he's saying. You upheld white privilege, and now you're using the same provisions on equality to block efforts to bring democracy and bring social justice, whether it's for race or women. The court's ultimate blow to the Civil War amendments and to the equality of Negroes came in Plessy versus Ferguson, in upholding a Louisiana law that required railway companies to provide equal but separate accommodations for whites and Negroes. And I argued in the EWS case that this reminds me of Plessy and Ferguson, because the government actually argued that they want to put forward classes and backward classes in two different compartments. And I said, it's unfortunate they are using the word compartments, because this takes us back to Plessy and Ferguson. Separate but equal. Separate but equal, right? Accommodations for whites and Negroes, the court held that the 14th Amendment was not intended to abolish distinctions based upon color, or to enforce social as distinguished from political equality, or commingling of the two races upon terms unsatisfactory to either. Right? And then we say, I do not believe that the 14th Amendment requires us to accept that fate. Neither its history, that's the amendment that introduced the right to equality, neither its history nor our past cases lend any support to the conclusion. See, this is the point which should have come in Chempakam Dorai Rajan. Neither the history of the Constitution, nor in their case, past cases, but this was very new, so that doesn't apply. The history of our constitutional struggle, the history of our freedom struggle, does not lend any support to the conclusion that a university may not remedy the cumulative effects of society's discrimination by giving consideration to race in an effort to increase the number and percentage of Negro doctors. That's exactly what happened in Chempakam Dorai Rajan, Medical College. The government had an effort to increase the number of doctors from excluded communities, and said, don't use the 14th Amendment to stop that. The court long ago remarked that in any fair and just construction of any section or phrase of the Civil War amendments, it is necessary to look to the purpose, which we have said was the pervading spirit of them all, the evil they were designed to remedy. That's what the court should have looked at. What is the evil that Article 15 is designed to remedy? It was not discrimination against Brahmins. They should have used it to address the evil that it was designed to remedy. Right. So I won't take any more time on this, but I'll certainly invite you to read this extraordinary, stirring dissent by Thurgood Marshall. I know, looking at this class, that many Thurgood Marshalls are sitting here, and they will emerge and they will write this kind of dissents, of which we will, or main judgments, not dissents, of which we will all be proud. Okay, now, so this is just to sort of conclude the methodology of what we did yesterday. Now what I want to do is I want to move to the doctrines that have been the doctrines in the area of religion and caste and reservation. Sorry, I'm switching these glasses, otherwise I can't, I don't like bifocals, because I tend to sort of trip when I look through the wrong part of that. So let's start with let's start with caste. What is caste? And so let me start with the latest Supreme Court's doctrine on caste, right? The basic doctrine of the Supreme Court on caste is the Constitution wants a casteless society. This is a theme. Now, seems very unexceptionable. Right? But what do you mean by caste? Then we'll understand what it really means, a casteless society, when we go a little deeper into this. And then you understand that according to that doctrine, what they mean is not varna, but jati. They don't mean a society without varna, they mean a society without jati. So let's look at the recent judgment, August 1, I believe it is, 1 August 2024 in Punjab, state of Punjab versus Davinder Singh, where Justice Pankaj Mittal has written, a very important judgment, and he says, para 59, I am of the firm view that in primitive India there was no existence of any caste system. Right. Sorry, can you see this at all? Can you see this? No, it's too small. Okay.
Screen here.
Sorry.
We can just make it full screen. Yes.
No, it's view. It's view. I go here. Yeah. Okay. I'm of the firm view that in primitive India there was no, little bit more visible now. Of any caste system, there was categorization of people according to their profession, talent, qualities, and nature. This can very well be reflected by verse 13 of chapter 4 and verse 41 of chapter 18 of the Bhagavad Gita. We know all that. Chaturvarnya Maya Srishtam Guna Karma Vibhagashaha, and so on. And he then goes, says, now here is where we are going. We are bypassing all the process and going straight to axiology, right? Straight to Lord Krishna. Lord Krishna says that I have categorized humans in 4 varnas, according to their nature and characteristics. So there's no doubt which axiology is driving the view of the Supreme Court in this judgment. Gita promotes only promotes varna system, which is different from present day caste system. This is the doctrine that we must promote the varna system, but we must have a casteless society. It lays emphasis on abilities, qualities, and consciousness of a person to have a balanced structure. Then it describes in detail the caste system. So I'm just going to stop here, and I'm going to take this further and in a different way. Let me just put this, minimize this, get this off the screen. Okay. Now, let me get out of full screen also. So now what I want to do in the next few minutes is really to understand what exactly is caste, varna, and jati. Now, again, very little time, I'm just giving you bullet points. If you look at sociologists, from Professor Bourdieu downwards, G.S. Bourdieu, who is considered to be the father of sociology, a great scholar, respected internationally, he says in his 1932 book, Race and Caste in India, Caste and Race in India, or Race and Caste in India, I forget, that there is no general definition of caste. He gives 6 characteristics, but he says there is no general definition of caste. That pretty much continues. We are not able to get a clear definition of caste, the Portuguese word of Latin origin, which simply means something pure that is cut off from something impure, from the European meaning of it. And so the Western scholars define caste as in different ways, as a system of regulation, a system of division of society into different groups based on vocation and so on. So these are the kind of traditional definitions we get. But there's no real, the real scholars say there is really no general definition, because there are so many divisions of society. How is class different from caste? That also is a division of society and so on. Then we contrast this. And similarly, if you look at the Supreme Court judgments, there is no real definition of caste. We say casteless society, but no one defines what is caste in a clear way. I have not come across any judgment that has a clear judgment definition of caste, and I've searched extensively for it. They borrow from these sociological definitions. And if you look at the scholars who have worked on caste, they're mostly sociologists, 1 or 2 historians, 1 or 2 people who are civil servants trained in English. But perhaps Dr. Ambedkar is the only trained lawyer, and maybe uh, um, maybe one other person was also a lawyer. I'm not sure, so I'm not going to say it. But Dr. Ambedkar was probably the only person trained as a lawyer who's actually worked on caste amongst the very distinguished scholars on this topic. So Supreme Court also doesn't give us a definition. In contrast, Ambedkar has a clear definition of caste. Phule has a clear understanding of caste. No confusion. Narayana Guru has a clear understanding of caste. No confusion. Because they are victimized by it. They know what it is. Famously, Dr. Ambedkar says this is a system of graded inequality. As a 25-year-old student, he already defines it very clearly. In his Columbia University paper, Caste, its mechanics, genesis, and mechanics and genesis of caste, he defines it basically as endogamy. It's a system of endogamy. That was 25-year-old Ambedkar. But he evolves to, or takes it further. While staying with endogamy, he expands it to say, in this very beautiful way, he says it's a system of graded inequality. When I argued this Sabarimala case in the Supreme Court, in the Kerala High Court, I argued that this was also a practice of untouchability, to say no one except a Brahmin can enter, Malayalam Brahmin can enter this sanctum sanctorum. So I searched for definitions of untouchability extensively. I found a book by a very celebrated scholar who unfortunately died recently, Anikit Javare, on touching. Very wonderful book on just what does touching mean to human beings and untouchability from that. He doesn't talk much of untouchability, but he talks about touchability and touching, how important touch is. So you realize that untouchability is a deep infliction of pain on a person, to say you're untouchable, because touch is so vital to a human being. It's not just a casual thing. You're destroying the soul and spirit of a human being when you say you're untouchable. Dr. Ambedkar defines untouchability. He's the only person. I talked to many of the current sociologists personally on the phone. They all said, no, we don't have. There's very little work going on untouchability from a theoretical point of view. Finally, I found from Dr. Ambedkar a powerful definition of untouchability. He said, untouchability is social nausea. Social nausea. So we have on one side proclamation of a casteless society, but no clarity on what is this, what is caste for us to be free of caste. Yes, we all want to be free of caste. Dr. Ambedkar said, not as casteless society, he said, annihilate caste. But there's no clarity about what it is. But there's plenty of clarity on the other side. Another axiology which has a clear definition of what is caste, but you will not reach out to that axiology. Why? Because that axiology is pro-democratic. But the statement, that the doctrine that we want a casteless society is based on an axiology that is anti-democratic. Why? Because we must now understand what is Varna and Jati. But before I do that, let me say that I will give you my own, after many years of struggle with it, my own understanding of what is caste. My understanding of caste is there's a reality in all countries in the world that there are social groups. These social groups are generally organically formed. They may be ethnic, they may be geographical, whatever it is. There are a variety of social groups. Human beings have families and social groups. That's why we say humans are social animals, right? We form groups. Now, when you want to come and control a place or control any group of people or control people, then you can either regulate them as individuals or regulate them as groups, and usually as a combination of the two. You regulate individuals and you regulate groups. The caste system is a system of regulating social groups. The interaction between social groups, deep, detailed rules on how groups can interact with each other socially, politically, economically, how you can speak to each other, whether you can eat together or not eat together, what kind of hair style will you wear, can you wear slippers or not. Your entire spectrum of rights as a human being under this caste regulatory system is determined by which group you belong to. Now, one way to understand this is gender. Gender is another way of regulating relationships between two groups which are artificially created. And when men and women interact with each other, this is so deep in our conscious that we have a tough time transcending that fictitious classification and saying we are just relating to each other as human beings. There's no real difference between us, except in a small aspect of our biological function of reproduction. Otherwise, we're just human beings. But two groups worldwide have been created, and we can only interact, which regulate the interaction of human beings with each other and make it almost impossible for us to interact with each other as human beings without being conscious of the fact that we belong to these two groups, men and women. Now think of that and come to caste, and you'll understand this is a very much more detailed and much more complex system of regulating the interaction between all kinds of groups. And it is not just regulating the Pulayas and the Parayas and the Chamars and so on. It is also regulating how Ayyars and Iyengars will interact with each other, how Nambudiri and Pandit will interact with each other, how Rajputs and Brahmins will react with each other. Right? It regulates everyone, everyone. And through regulating this code of regulation, you are actually regulating individual human conduct and constraining individual human conduct. And my submission is, this also regulates the relationship between Abrahamic religions and those who fall within the caste system, because we have another set of rules on how we interact with them. Those who eat beef, or those who do engage in habits that are not permissible under this regulatory system, prohibited, because it controls how you breathe, how your diet, it controls everything. And frankly, we find it very difficult, therefore, when Indians meet, to interact with each other without first understanding which box do you belong to. So that's why Dr. Ambedkar said, annihilate the system, because you will never have freedom in this country unless this system is annihilated. Because it regulates, even if an Iyer and an Iyengar want to interact with each other as just human beings, they have to annihilate caste. They have no choice. This is not a fight just for the Chamar and the Pulaya, it's a fight for the Iyer and Iyengar also. They have to annihilate the system that regulates how they will interact with each other. Otherwise, there is no moving forward for this society. So this is my understanding of what the caste system is. It's a system of regulating interaction between groups in micro detail that affects everyone and constrains everyone. It is like gender system, equally powerful, except its scope and reach and jurisdiction also includes women. So women are also put into groups, and how women can interact with each other is also regulated. If you're a Brahmin woman and a Chamar woman, how you interact with each other? This system regulates that. At least in other countries, women can interact with each other as women. But in India, that's not possible. Not possible. So for all of us, annihilation of the system of regulating how we interact with each other must be our first priority. Now, let's look briefly at Varna and Jati. We know that Dr. Ambedkar has described it correctly as a system of graded inequality. Narayana Guru comes up with a very, very important and interesting theoretical definition of what is Jati and Varna, which is very little known outside Kerala, but I think deserves to be known. Narayana Guru was a great scholar in Sanskrit. He studied Sanskrit a lot. He's written 14 books in Sanskrit. He speaks Sanskrit. He's a deep scholar of all the Sanskritic religious texts. So after the study, he basically said that Jati means Janma Riti. Etymologically, the word Jati comes from two words, Jan and Katin, half ka, half ta, tin. So tin is a verb noun that translates some phenomenon into a product. So kr means kriti, sorry, kr means creation. You add katin to that and you get kriti, a product. So a phenomenon, a verb noun, and you get a product. Kr plus tin is kriti. Jan plus tin is jati. So I can say my Janam was in 1953, very ancient man for you, and I would be right. But I cannot say my Jati was in 1953. So it's not birth. So Narayana Guru says, Jan plus Katin, Jati, tells us what is the mode of your birth. So he says, if you're born from a yoni, a woman's womb, in a particular akar, 2 years, not 4 years, one head, not 3 heads, one akar, one yoni, then you are the same jati. So elephant is one jati, butterfly is one jati, humans are one jati. So he doesn't say there is no jati, he says one jati for humans. Because we are born through the same Janma Riti. It's not that some humans are born by a mother delivering a child and others are born by the father laying an egg and the egg hatching. There's only one method of birth. And that's what science tells us, right? It's one of the criteria for a species, that the reproduction and birth is the same in one species. So Guru says there's only one jati, and he says, ha kashtam, he says, what a pity that there is no one, kopina, there is no one in the world who does not know that all human beings are one jati, have the same mode of delivery, except Brahmanadis. What do Brahmanadis believe? Brahmanadis believe from the Rig Veda that there are 4 methods of birth. From the head, the shoulder, the thighs, and the feet. So 4 jatis. The word jati is not used, but jati is created in the Rig Veda Purusha Sukta because jati means method of birth. And the Purusha Sukta says there are 4 methods of birth. And Guru says, wrong. There's only one method of birth. And what is Varna? Varnanam, in Malayalam we say Varnanam, using a Sanskrit word. Varnam or Varna means description actually. It's not color as in skin color. It's coloring, like, coloring a picture, fleshing out, describing a picture, or giving description. So Varnanam simply means description. So the Varna, like in this Chaturvarnya, Maya, Srishtam, Guna, Karma, Vibhaga, Shaha, and so on, which came later, simply sets out, and in other Shastras, simply set out the rights, responsibilities, status of these 4 jatis. Because Rig Veda actually in the Purusha Sukta sets out the method of birth for lots of things. The earth, the sky, animals with 2 rows of teeth, donkeys, all kinds of animals, everything that they need, the Indo-Aryans need, the method of creation is set out there. And in the middle of that, they simply say Brahmin, Kshatriya, Vaishya, Shudra. They don't say human. They don't refer to anyone else. So they say all these things were produced through this riti. So Prithvi was from the feet of Virat Purusha, like Shudras. So they describe the Janma Riti, or the method of creation of all these various named, enumerated entities. And amongst them, they mention Brahmin, Baniya, Brahmin, Kshatriya, Vaishya, Shudra. And so there are 4 jatis created in the Purusha Sukta. Donkey is also a jati. It's mentioned in the Purusha Sukta. And the description of that is Varna. So actually a casteless society should be a society, leave the Portuguese word aside. We want a society which accepts that there is only one jati. Guru said in Malayalam, Oru jati manishyan, one jati for all of humanity, because there's only one method of birth. That's what we want. If that's what a casteless society means, that means we have no varna. But what is now jati used for? See, all these years, a vast majority of people in this country were considered outcasts. What does that mean? You're out of caste. You don't have a caste. For many years, caste Hindu meant only the Savarna Hindus, Varna Hindus. Others were outcasts. Now, since the constitution has come into effect, especially, the word Hindu and the word jati is applied to all the outcasts and their social groups. But they have no caste. So when the Supreme Court means casteless society, it means a society without the social identity of the former outcasts, but with Varna and with Hindu. Those 2 social identities have to be preserved. But somehow the social identities of these poor marginalized people, Chamar, Pulaya, this is somehow a danger to society. It's dividing society. But Hindu is not dividing society. Varna is not dividing society. Gender is not dividing society. But the identities of these poor, impoverished people, social identities, is somehow very dangerous. And that is jati. So when the Supreme Court says we want a casteless society, they actually say, he actually discusses that we don't want jati. Judgments say that. Jati is bad. Varna somehow, they have got this narrative that Varna deteriorated and became jati. It's not a scientific narrative at all. It's drawn straight from axiology. Jati is Varna. Varna is only a description of jati. Both have to go. We don't want that. Till today, there is no Dravidian word for jati or Varna. It's only a Sanskrit word. We have lots of words like Taravad for what we might call Samudaya, Sama Udaya. If you remove Varna and Jati, there's no stratification, there's no hierarchy. The Pulaya and the Nambudiri are just Samudaya. They can coexist without hierarchy. The hierarchy comes from this idea of the different species. So when we now say these are Jatis, we are actually telling them you are a different species from us. So we should never call anyone a Jati, because we are telling them that you are a different species from me. Yes, yes. Yeah, thank you. This is an alternative axiology on Jati. That we reject Jati and Varna, we accept Samudaya as organic, created by people, constantly changing, not subject to legislation, subject to coming together, splitting apart. All of us are part of social groups. Our resident associations are social groups, and so many social groups are formed and changed, and that's at the heart of society. And many of these are cultural groups which speak the same language, subject to the overall constitutional framework of the norms of agreed from our axiologies, drawn from various axiologies globally, because we are one humanity. We draw from a common axiology for all human beings. And then we come up with these 4 sets of ideas of liberty and equality and fraternity and dignity as having to be accepted by all human beings everywhere for us to live together in peace. Subject to that, we should have freedom to form and live in our own groups, social groups. That can only be a solid foundation for democracy. These groups are a danger to oligarchy, but not a danger to democracy. They are the foundation of democracy. And we should never create hierarchy and create alienation between groups and hostility between groups. So there is an alternate axiology, understanding of Jati Varna, and then we read caste as referring to Varna and Jati and Varna, the system of social regulation that came out of the Indo-Aryan stable, which has to go. But leaving beside as a residue the wide diversity and range and freedom and democratic freedom of communities and social groups to grow. That's the alternate axiology. Now, if we read the Constitution from this point of view, we will get doctrines which are different, but the doctrines that are now, the doctrines that have come from the Supreme Court in several judgments and which reaffirm the Varna system, attack jatis and jati identity as bad, and therefore reservation for, we'll go to reservation as a next topic, maybe after the second session, we don't have time here. It's a way, opposing reservation is also another way of attacking the existence and flourishing of these communities which have been discriminated against. So this whole set of doctrines on reservation, on understanding of caste, we haven't touched religion yet, and I would like to actually also talk of religion before I end this session. I'll just maybe briefly do that and then move to a discussion. It is weakening our democracy. Now, let me turn quickly to Hindu, particularly religion and Hindu. On religion, again, saying very briefly that the definition of religion was first given to us in an organized manner in the Shirur Math judgment, famous Shirur Math judgment by Justice B.K. Mukherjee. He looked at the option. He was a great scholar. He looked at the option of defining religion using an American definition, which was simply an individual's connection with individuals' ideas about your connection with the creator if you believe there's a creator. That's all religion is, said at that time, the American definition that was available to the court. He rejects that. And he basically defines religion. Why did he reject that? Because it is confined to belief. That's the reason he rejected that. Yes, it's belief in your creator and in your relationship with your creator. But it's more than that, he said. It's also rituals and practices. So he brings in rituals and practices into the definition of religion and then protects rituals and practices. And the priesthood, which is in charge of rituals and practices, becomes very powerful through that definition of religion. Because rituals and practice is the livelihood of priests. You can think of God and talk to God. According to the Muslims in particular, they have no priesthood. Every Muslim directly talks to God. It's a very dangerous idea for the priestly class, professional priestly class, whichever background you come from. Today there are priests from all kinds of backgrounds, but it's dangerous to them. So we had religion, a doctrine that religion includes rituals and practices, not just your beliefs, faith and belief. That created Again, a continuity with the Raja era and the Raj era, and disrupted the possibility of developing gradually a democratic idea of what religion is. A complex question. I'm not saying there is an alternate idea that easily comes to mind, but this blocked off the development of a democratic idea of religion, where the power rests with, like in Islam and in Christianity, in Abrahamic religions and Buddhism and Jainism, the power rests with the individual member of the religion, who can select the priest, become a priest freely, decide on what is ritual, what is not ritual. That democratic approach to religion was torpedoed. And the other part is looking at the definition of Hindu, which comes most importantly or most comprehensively from another great judge, great scholar, Justice Gajendra Gadkar. Both of them were at one point Chief Justices of India. Justice Gajendra Gadkar, actually he writes it as Chief Justice shortly before he retires, few days before he retires. He writes in March 1966 in Shastri Yagna Purush Das Ji versus Muldas Bhudar Das Vaishya. He says, the term Hindu, according to Dr. Radhakrishnan, now he's reaching out to axiology, right? Dr. Radhakrishnan, had originally a territorial and not a creedal significance. It implied residence in a well-defined geographical area. Aboriginal tribes, savage and half-civilized people, savages. Aboriginal tribes, savages and half-civilized people, the cultured Dravidians and the Vedic Aryans. So an axiology that considers the common people of this country as savages, all and half-civilized, in a Supreme Court judgment written by a very distinguished Chief Justice, were all Hindus, as they were the sons of the same mother. So the Supreme Court suddenly makes everybody a Hindu. The census had already done it in 51, saying it's a residual category. The word Hindu, again, like the word caste, is very poorly defined. The Hindutva judgment of Justice J.S. Verma says it's a way of life. Other judgments also say it's a way of life. How can a religion be a way of life when it has to include rituals and practices according to the Supreme Court? How can you say it's a way of life? Are you saying, therefore, it's not a religion? So a lot of confusion on this. But Justice Gajendra Gadkar provides, a clear view. And he says, we are all Hindus. Why? We have the same mother, drawing from axiology. There is no other evidence for it that we have the same mother or there's a common descent. God knows. All humans may have a common mother, perhaps. But that's true of all humanity in the sense of we are born from a mother, all of us. As Narayana Guru says, we are all born from a mother, not from the mother or one mother, right? All of us. The monastic idealism, which can be said to be the general distinguishing feature of Hindu philosophy, has been expressed in 4 different ways. Then he looks at Advaita and all that. And then he says, this is the axiology of the Hindus. And then he says, they all had reverence for the past. So he brings into all Hindus must have reverence for the past. Turns our head backwards. Supreme Court. And accepted the Vedas as the sole foundation of Hindu philosophy. As the sole foundation of Hindu philosophy. The first amongst, and then he goes on, beneath the diversity of philosophic thoughts, concepts, and ideas expressed by Hindu philosophers who started different philosophic schools, lies certain broad concepts which can be treated as basic. The first among these basic concepts is the acceptance of the Veda as the highest authority in religious and philosophical matters. So, living just 80 kilometers from where India ends, if I go 90 kilometers, I'll fall into the ocean. The land ends in Trivandrum. The census told me I'm a Hindu because I'm a residual category. I don't belong to the 6, the 3 Abrahamic and the other 3 Indic religions. Then the Supreme Court comes along and says, by the way, Mohan Gopal, you have reverence for the Vedas. I don't know the Vedas. And the Vedas are your highest and sole religious and spiritual authority, philosophical authority, says the Supreme Court. This is mass conversion into Hinduism. Involuntary mass conversion into Hinduism by the Supreme Court of India and the census. So you're constructing the Hindu religion. You're constructing a body of Hindus and providing a platform for the development of Hindutva. The Shilanyas of Hindutva, amongst others, was laid by some judgments of the Supreme Court. Now, in contrast, to conclude, Narayana Guru said in 1925, there is, in public, in a statement, there is no religion called Hinduism. There is no, Hinduism is not a religion. Great scholar, not just a guru in the real sense, not a Swami or a priest, a scholar. He said there is no religion called Hinduism. Ambedkar said in 1936, there is no Hindu society. A different axiology. What did Narayana Guru, how did Narayana Guru explain this? Narayana Guru said, initially, as we all know, Hindu was a geographical indication of people who lived in a certain territory. But he said, look, today things have evolved. And over the last few centuries, he says, Hindu has become a group name for 11 Aryan Brahmin religions, which he names. So like Semitic is a group name for 3 Abrahamic religions, Hindu is a group name for 11 Aryan Brahmin religions. I can name them, but I can name them during the interaction or some other time. I won't take time for that. But he named the 11 religions. And he basically told the people, you have no, there are people who believe in it. I respect them. They have reverence for the Vedas. They consider the Vedas their supreme authority. That's fine. That's their religion. Parsis believe in Zen Avesta. We respect that. That's their choice. We have no quarrel with that. But for the rest of us, he said, we have no place in these religions. We are not supposed to read their Shastras. We can't enter their temple. We can't be their priests. So don't, you say you believe in all this, no problem. But don't tell me it's my religion. Don't tell me it's a religion of my country. Don't make it the axiology of my court. Simply because you belong to that group of religions, you can't impose that axiology on me through the court. We respect that. It's like if Justice Rohinton Nariman had written judgments all based on Zen Avesta and said, this is the law of the land. We respect him. He is actually a priest in the Parsi tradition. We respect that. But he's not trying to tell me I'm a Parsi or I should, Parsi is my religion or the religion of this country. So Guru says there are 2 consequences of saying my religion is Hindu. One is we accept these principles that there's supremacy of the Vedas and supremacy of the Brahmin priest. Secondly, he says, the moment you accept you're a Hindu, then automatically you become alienated from other religions. They are not my religion, especially Islamic, Abrahamic religions, Buddhism, Jainism, with which these 11 religions have had a conflict. So he basically advises, don't use Hindu as a common name. Use something else. And he suggests Manava Dharma. He says, the religion of common people is, we go to all these 11 temples, we go to the mosque, we go to the church, we pray before a tree, we do whatever we want. We control our own spirituality. He says, that is fine, nothing wrong with that. But the name of that religion is not Hindu. It's something else. And he says, perhaps it's Manava Dharma. So another axiology is available. The consistent theme I'm saying is, there is an axiology that is anti-democratic, that is drawn from one stream. There are powerful alternate axiologies available in this country, which are pro-democratic. And by not drawing from them, these judgments are weakening democracy rather than strengthening democracy. So let me stop here and then We have 20 minutes at least. You said till 1? Till 1, no? Yeah. 20 minutes, we can spill over by 5 minutes if necessary. And then I will talk in the second session about, I'll try to squeeze in reservations and equality and liberty, the doctrines. I'm focusing now on doctrines. So the doctrines I'm now saying are the doctrines of what is Hindu, what is caste. These have been taken from an axiology and formulated in such a way to provide the platform for the growth of anti-democratic forces which have never accepted the constitution and the republic and have always worked against it. And those interpretations were adopted, just as Justice Marshall says, the Supreme Court for many years accepted the white racist interpretations of the constitution and weakened democracy. Okay, let's take the questions.
Good afternoon,
Yes.
sir. So this side.
Yes, hi.
Good afternoon, sir.
Good afternoon.
So when you mentioned the Shri Shirur Math case and Dr. Justice
B.K. Mukherjee.
Yes, his judgment. So you said that the idea of religion, the definition of religion that came up, blocked the path for a democratic idea of religion. I want to understand
what I'm saying is that the definition of religion, instead of being, see, Article 25 gives right to religious freedom, the right to faith, right to freedom of conscience, and the right to faith and belief in religion, right? The freedom to profess, practice, and preach religion to individuals, right? And that does not include the power to decide what is a ritual, right? So the individual becomes the repository of religion power, the constitutional power to religion. So what has now happened from Justice Mukherjee is he's extended that freedom to temples, to institutions. Although Article 26 does not give institutions the freedom of religion, only individuals have it. But he said the Mahant has the freedom of religion as an individual, and when he acts as the head of the temple, he's exercising his individual freedom of religion. Therefore, the temple has freedom of religion, right? So all these judgments, bringing in ritual as into the definition of religion and saying how puja is done is part of religion, therefore must be protected, has put a lot of power into the hands of priesthoods and institutions, so that today these I can be told that I cannot be a priest in the Shabarimala temple, and the only reason that the High Court says is that the Tantri of the temple says there is such a tradition. It doesn't matter what anyone else says. The Tantri's word, and the arguments were made, the court did not reflect that in its judgment, but the argument was made before the court that the constitution stops at the door of the sanctum sanctorum. It does not enter. Now, what puts the constitution out of the sanctum sanctorum is this definition of religion. Because what is this? Even the creation of the sanctum sanctorum is created by priests who say this is the sanctum sanctorum, this is when it will open, this is when it will close. Whereas in the religions of the native people of the pagan religions, we are all basically pagans. Pagans means those who don't belong to organized religions, right? We kept these deities in the open air. Even I went to a museum in Thrissur, they keep the deities in the open air because they said they should never be put under a ceiling. They should be in the open air. They were open to everyone. So who came and enclosed these deities in a room and shut it and opened it and said they can only be open, they can only be, only certain people can touch the idols. Otherwise, any kid could go and play on those idols, you know, when they existed in the open air, right? So you created a definition of religion that gave power to a priesthood to control the definition of religion and religious practice, and disempowered us. Now, democracy, social democracy, includes the individual, the power over religion also to vest in the individual, not in an organization or a priesthood. So that, therefore, it is undemocratic. In my view. I'm just offering my view. It's not necessarily the right view at all.
Thank you, Professor.
Yes,
I think listening to you has produced a churning that will remain for quite some time. I think I must first say that it's one of those rare occasions where what we say in whispers and to each other is said in a erudite manner using the platform that you have and the position that you have. And I think that uh, that is very rare.
Thank you.
I have two short questions.
Yes.
One is from what you said yesterday,
Yes.
and the one follows from your lecture today. Uh, Yesterday, you said, and I think I agree with it, that we have to think that is the constitution which makes us not as much as we make it. And in that, I'm trying to think about what you said when it comes to national security. However, if what the constitution makes us when it comes to the question of national security is itself anti-democratic, is itself anti-free speech, and I'm referring to the language of the constitution when it comes to Article 22, which sanctions preventive detention, which most people who believe in constitutionalism will agree has no place in the text of the constitution if it is a liberal constitution. So how much of, so isn't it, how correct is it to implicate the court in uh, its reasoning when the words of the constitution itself are tainted, or it fetters, or it goes against the freedom that we have? A short addition to that also is that you chose two cases, Champakam Durai Rajan and
A.K. Gopal.
A.K. Gopalan. If that is the legacy of the court, then the legacy of the court in the same year is also Anwar Ali Sarkar. It is also Romesh Thapar. It is also another free speech case, Brij Bhushan versus State of Punjab, if I'm not wrong. So these were also the cases where the court struck down fetters on liberty. The court struck down also the way Anwar Ali Sarkar was decided, that without going into procedures established by law, they entered the question and gave content to equality. I agree with you, but I'm saying that how do we understand the legacy of the court or what the bench? Because these were also.
Very good question. Can I start with the second one and then come to the
Yes,
first?
there's another question that you said.
Yes.
And I think it's very interesting how you touched upon the cases on religion. And I agree with it. I'm just trying to think of a framework if we have to call out bias. That I have also thought that how can the court, can we say that the court is delving into or is deviating from its exercise of public reasoning and going into non-public reasoning when it takes up precepts from a particular religion and does content feeling to the ideas of state neutrality or non-discrimination or freedom of religion, which is that the reasoning has to come from a text that is common to all. But if the underlying basis of it is that Indianization is equated to being Hindu, or if it is said that Sarvdharma Sambhava has its basis in these precepts. But when it comes to minority religion, one looks at its practice and not the precept to say that mosque is not an essential feature of Islam in a case that had to do with the painful disappearance of Babri. What does it say about the public reasoning function of the court if the public reasoning function is hijacked by ideological precepts of a particular religion?
Yes.
So yeah,
And
thank you.
very good questions. I'll very quickly respond to each of those. And if I forget anything, please remind me. First, I want to start by saying I'm making a distinction between precedent and doctrine, right? And I'm looking at long-lasting doctrine that still influences the thinking of the court as an institution across generations. Right? So when we look at some of these definitions of equality, we'll talk about equality in the afternoon. They have not had a doctrinal impact. They have given relief. They provide precedent, but they've not had the kind of doctrinal impact like the doctrine of legitimizing reverse discrimination has had. So I'm not, so if you look at the court produces lots of decisions. A bulk of the decisions are, in my view, administrative law, not constitutional law. The normative issues are constitutional law. But if you take constitutional law, then there are a lot of constitutional law decisions that may protect rights, secure democratic rights. There are a number of very good decisions that protect democratic rights and do produce good pro-democratic doctrines also. But I am now concerned that we have lost our democracy. So I am trying to identify those doctrines that are responsible for our losing our democracy. So it's like if I have a heart problem, but my lungs, I don't, but if I had a heart problem and my lungs were not bad and my lungs are okay, but my lungs are good, I am focusing on how to fix my heart. That doesn't mean my lung is bad. So I do accept that there are a number of areas where like the doctrine that has come out of the Vishaka judgment, right? That's a lasting doctrine. The statute and the cases on domestic violence, right, produce good doctrine that is pro-democratic. But I am now trying to identify the crucial doctrines which of the Supreme Court which have weakened democracy, and focusing on that. So thank you for that opportunity to clarify that. And those are the doctrines, main doctrines I am identifying on, basically touching on democracy, on secularism, on caste. These are the areas where the Supreme Court has been very weak. And the reason is not because they have not applied, but they have the wrong doctrines. And we are undemocratic. But in other areas, they have, gender is an area where they have a lot of good doctrines, because gender actually, the whole conflict here is a conflict between the pagans and the Hindus, basically, right? So, but women come across in both sides, so there's no difficulty in sort of developing gender to some extent, although without. See, we are always looking past. We are required as Hindus to look to the past, as Dr. Gajendra Gadkar says. Supreme Court wants us to look to the past. And there we can't transgress the ideas of women that are traditional. But within that, some kind of small changes they've agreed. So that's my clarification on that. That's my inquiry. And I'll be very glad to hear of more doctrines which are damaging to democracy, so that we can surface them, identify them, challenge them, rectify them, so that the damage to democracy can be reduced. That's my objective. The second point that you raised, what was the second point you raised? Yes. Okay. So there, what I'm saying is, ultimately, whatever reasoning we go to, we take, public reasoning, methodology we use. To me, the central question is, ultimately, you're going to go to an axiology, to a social philosophy. And I want to know which is the axiology you're drawing from. Now, the public reasoning may stop at precedents, which have already drawn from the axiology in the past. So you only cite Supreme Court precedents or some other US Supreme Court or House of Lords judgments or some legal principles. Fine. But I want to know what axiology do they draw from? Because at the end of the day, these normative questions have to draw from an axiology or a morality, right? Axiology in the sense of a morality produced by an axiology, which is what do you give value? That's beyond the court. The court simply, but the production of that value is what we call axiology, right? So we have to be conscious, where is it coming from? And my point is, where the Supreme Court is drawing from, unlike in Vishaka and so on, is drawing from these traditional axiology, right? The old axiology, then that is anti-democratic. And so you're going to produce anti-democratic doctrines. And you are not looking at more democratic axiology, which you can draw from. That's the narrow point I'm making, right? And so I've also said that whatever axiology they draw from, now they're even short-circuiting the public reasoning completely, and they're going straight to the axiology. To some extent, I appreciate that because it's more honest, rather than disguising it as some judgment and some some judge and some book and all that. Saying very honestly, this is we are going to keep Varna. We are going to take all the pagans and make them Shudras, and we're going to keep the Varna system because it's good. Even EMS Namboodiripad has written that the Varna system has served society well. That's their view. He's supposed to be a Marxist communist, right? In fact, Professor Dilip Menon has written an article about him called Being Marxist the Brahmin Way. You can read it, it's available online. So, that's that. Is there anything I left out? Okay, great. Thank you. Thank you for those very wonderful questions that helped me.
Hi, Professor.
Yes.
I have
Yes.
one question right here. Yeah.
Hi.
Thank you so much for giving this lecture. My question is related to what Professor Prasoon said as well.
Sure.
So, as per your analytical framework, you say that when judicial actors skip to the axiology phase without considering how these norms are built, without looking to the precedent, it poses certain problems, and you're contextualizing that in how certain recent decisions have made these references to dharma and Hindu ideas and so on and so forth. My question is, why exactly is skipping to axiology wrong? Especially when we have a mass of judicial reasoning that's sometimes difficult to maneuver, right? Let's say we have a particular social end, a legitimate democratic end. If we're rooting that in a particular axiology that might help serve that end, is it necessarily wrong to skip through that to that phase?
Really excellent question. Yeah.
I just think that if we go through precedent, sometimes we're limited by judicial reasoning and we're not able to reach with the foundations of whatever moral question we have to address.
Thank you for that very good question. Here's my thought on that. There is a process by which axiology is brought into law. And that is by axiology is a process of deciding what is valued and what is not. Right? So once there is, and that is fought over very bitterly. That fight must take place in Parliament. And it must be reflected in the Constitution of India. And then it must be drawn on by the courts. So a judge has no business to bypass that whole process and pick and choose the axiology that he believes in or she believes in. So otherwise, so that's what we are increasingly seeing now. Now take subcategorization of scheduled caste. Why didn't they move and they could have amended the constitution and said, okay, we are going to subclassify scheduled castes. Why do you want to bring it to the Supreme Court and skip that whole process of deciding what is the value? There is the value of the identity of the collective identity of scheduled caste communities and the separate the identity of scheduled caste communities, and whether they are helpful or not for them to get benefits. Shouldn't their representatives debate it in Parliament and representing all these groups, and then decide what the principle should be, and then put it in Parliament? So that's what we do in a democracy. We can't empower 5 people sitting on a bench to sort of skip that whole process and say, I'm going to give value to this. Then we're back to Raja era and Raj era.
So I'm so sorry, just a small follow-up question. I don't want to take any more time.
Sure.
But when you are saying that we have to refer these questions through Parliament, a lot of the times there is also that legitimacy issue, whether representation in Parliament is actually representative of the issues that the public has to consider.
Of course.
So in that case, we have this dual problem of both institutions not being representative.
Yes.
And so this whole idea of following a particular process, does that really hold weight?
No, but the question to me is, even if it is a value that I believe in and I like, and one single judge produces it, I know it's weakening democracy. Because we are fighting for representative democracy. As I said, the basic battle is between an oligarchy and democracy. This is what the fight in our country. That's what we're fighting over now. So what we want is representative democracy. So we will have to fight in the public sphere to achieve representation and say Parliament is not representative. So when Parliament rushed through EWS, suddenly people realize that Parliament is not representative. Otherwise, this would never have gone through. And it really opened the eyes of people to non-representation of Parliament. That is why today there is a demand for census, because EWS got passed by Parliament and endorsed by the Supreme Court with the stirring dissent of Justice Butt. Even in Parliament, no one dissented. Only Justice Butt is perhaps the only person in this country who spoke on behalf of 80% of India and dissented, right? But that opened the eyes, and Justice Butt's judgment helped open the eyes of people. Look, there is another view possible. Like when I read to you Thurgood Marshall, it opens your eyes to another perspective, saying, look, how can you use equality to protect the privileged? That's not why we have this. That's not this. The whole enterprise is not that. So therefore, I think that we want to put these things in the US. It's a controversial doctrine. You know it. It's called the political question doctrine. The courts don't deal with political question. And we have not really, even in the US, it's complex, but we have really been conveniently ignoring it, especially of late, in a sense where the political forces are putting the very complex political issues into the court and getting the courts, a small number of judges, to decide them. But in the long term, it makes people realize that why the state, whichever government it is avoiding Parliament is that Parliament is not representative. And we have no voice there. So we are electing people who are ignoring us and getting things done through the court. So all this is helpful in the long struggle for democracy. We are only in the 8th decade of our constitution. We have many, many decades to go. You said the constitution has different provisions. I didn't address that, progressive and regressive. Yes, that's why it's a compromise. That's why I consider the constitution as a site of struggle. The question is, how can we use what's available? I would say there are only about 20, 25 provisions, which I list somewhere, which are really powerful provisions supportive of democracy. But we must use that as an arsenal for democracy, to democratize society, and then have representative state, and then use that to make the constitutional content also more democratic. So I wish there would be a time when we will have an amendment that will delete the preventive detention provisions from the constitution. It's within the power of Parliament to do that, right? It will delete EWS from the constitution, right? So we have to fight for that kind of politics in our country, and public opinion. Politics simply follows public opinion. We have to create public opinion for that. But yes, the constitution is not a holy book. It is not a pure book. We are not swearing allegiance to it. We are swearing allegiance to the republic and to democracy. And we are very grateful that we have a parliament that gives us a pretty powerful arsenal to fight for democracy, which many constitutions, including the US Constitution, did not give. In fact, the US Constitution was very pro-slavery, as you know. They had provisions that actually protected slavery in the Constitution, including counting the number of people. A slave was counted as 3/5 of a person, right? So if you had more slaves, then you would get more representatives, and so on. So, in fact, this dissent of Justice Thurgood Marshall discusses that in detail, the US Constitution and slavery. It's a very powerful dissent to read. So, yeah, so it's a constitution is a site of struggle. We must use what we have there to fight for democracy. Yes, of course. You're the host.
Professor Gopal, I
Yes.
think your insights have been really very much appreciated, and especially the today's speech. And I just want to make two observations. One, a comment, and one a kind of observation. I think it's more for the purpose of completeness. The first one, we tend to focus on the final judgment, that is the Supreme Court judgment in Champakam. But if you go to the Madras judgment, which is a full bench judgment of 3 judges, Chief Justice Rajamannar, Chief Justice Rajamannar, then Justice Vishwanath Shastri, both eminent judges, and we have a third judge, Justice Somasundaram,
This is the Madras High Court judge.
Madras High Court. We had our own third good marshal. We don't read him. This Somasundaram clearly writes in the last few paragraphs the history of these provisions and says we cannot ignore the directive principles, particularly Article 46, because the state relied heavily on the directive principles. The majority rejected it, just like the Supreme Court did. And there's a welter of US case law, where which was pressed by the state of Madras. That's the interesting aspect. The second is my own observation is, I think we are giving far too much weight to Champakam now, not merely because of the amendment. The amendment and the reaction was very swift. And if one goes through the debates, especially the prime ministers, it was very unequivocal that we didn't think that a separate 16.4 kind of provision was necessary, but you have compelled us to do it, and it was carried with unanimity. But more importantly, the understanding which you attribute was abandoned in the mid 60s. And the first seed of that thought came from Justice Subbarau's separate opinion in Devadasa, when he said that 16.4 is only an emphatic. See, he says 16.4 is an emphatic way of what 16.1 says. And that minority became the majority when the 7 judges adopted it in Thomas. So now that's the law of the land, and Indira Sani has kind of sanctified it. So it is no longer, now you go to unenumerated reservations. I was just talking to Professor Vasanti. You have of course, the proscribed grounds are in 15 are very clear. But when you come to 15.4, you don't have gender. And yet you have gender as entrenched statutory reservations, which the court has not struck down, but rather celebrated. On the reverse side, we have a reverse Champakam in Vijay Kumar, where the court said that although there is no 15.3 kind of provision, and there is no reservation for gender, it doesn't mean that it cannot be done. So I would argue, that's my view, that Champakam is a ghost which is unnecessarily being resurrected. It may not be. There could be other problems. There are other problems. And in my small chat with Professor Vasanti, she rightly points out that we still regard 16.4 as merely an enabling provision. Well,
I'm coming to that on reservations.
I tried to deal with it in the Maratha judgment because I have differed with some of those judgments and say that if there is contrary material showing that overwhelmingly there's certain communities who are backward, I would see that as an obligation by the state to enable that.
Thank you very much. I appreciate those comments. I am not trying to give particular importance to the Champakam judgment. I am trying to argue that Champakam legitimized the concept of reverse discrimination into our country, right? Under 15. Sorry?
Again, I'm a little problematic with that because I wonder when did we actually practice it?
Yes.
In the sense that soon there was an understanding, and that was clearly a communal geo in the sense that all seats were apportioned.
Yes.
Sometimes facts are important. There were 300 odd seats, of which what was in contention was 14. But that's not the important point. And it was a geo commissioned in 1921.
Right.
So clearly, the court went beyond its remit in making certain observations. But to say that it's continued to prevail, I would rather contest it because there is no, at least to my knowledge, there is no case which has relied on Champakam at the behest of some of the
Yes.
forward cast
Yes.
to
You
say
know, from
that
a
there is this.
point of view, I'm not looking at reliance as a matter of precedent. But if you look at the frequently repeated phrase, unequals should not be treated as equals, right? And implicit there is we have to protect, we also have to balance between the right of the marginalized to representation and the right of the others. Now, this idea begins that, because within months of the Constitution coming into effect, the rights of the privileged are protected. So the doctrine is you must protect the rights of the privileged. That idea has legitimacy, whereas in my view, it's an illegitimate idea. The privileged do not need any protection from the court or the law. The court exists only to protect the powerless, right? And Raja era and Raj era, the courts protected the powerful against the powerless. In a democracy, the courts exist only to protect the powerless against the powerful. And so Champakam, that is what I mean by reverse discrimination. The idea that somehow you have to balance the rights of the powerful and the powerless. That idea started from there. And from A.K. Gopalan started the idea that when it comes to order and national security, hands off. The government should be allowed to do what it wants and see what it does. Give them that, that presumption in their favor. Then if they don't give bail and there's no proof, you give bail and you question all that. But even that presumption is a very gross violation of the right to liberty, and only those who have suffered from it and stayed in jail unnecessarily know the cost they pay. So that's all I'm saying. I'm totally in agreement with you. I'm not trying to elevate Champakam to some kind of powerful precedent that has influenced. No, but it laid the seed of this idea that there must be a balance between the powerful and the powerless. Whereas the idea of the freedom movement was we've had enough of that balance. We now want the powerless to have power, right, and become equally powerful. So that's my main point.
Distinguishing between precedent and doctrine.
Right.
Because I do think that there is a certain way in which we look at precedent.
Yes.
And if a case gets referred to,
Right.
I think the default mode is happening, but it's important for us to distinguish that basic point you're making.
Yes.
That it's the thought there.
The doctrine, yes, the set of beliefs.
It's been kind of.
Actually, doctrine comes from doctor. Doctor means teacher in Latin. So doctrine is what you're taught. Doctrine is a principle that you're taught and you accept and you believe in. So I'm absolutely right. As always, very well put here. We've internalized this idea.
Internalized it in an unquestioning manner.
Unquestioning manner. That's right.
I think
that's
the
right.
critical
That's the
point you're making.
Yes, exactly. As always put better than me, but I could have. But so I think this idea that we have to reject this idea of we have to balance the rights of the sense of victimization of the powerful people, that we are victims now of this democracy and this equality and and so on. They're not victims. They're simply being put in an equal place. They're like men. There's so many associations of men who say we are victims of women's rights, right? They're not, they're just being put in their place where they deserve to be. Okay, thank you very much. But thank you, Justice Bhatt, for that excellent. Thank you. I wanted to get to reservations in this session, but I will, because this session, but I didn't, but I'll come to that briefly and then move to the others. Thank you.
Thank you, Professor Gopal. Thank you, everyone, for staying till the end of the session and all of the amazing, insightful interventions that we got from the audience as well. And we're all back dealing with that very fundamental question of how democracy structures the relations between the powerful and the powerless. And hopefully Professor Gopal will be able to address that through his discussion on reservations in our last session that will be happening at 5:30 in the evening today. We hope to see you all there. Thank you.